the preliminaries.
We don't want to preempt anything, but we want to see how far we can get with the witness.
It's not the second accused.
No, the second accused, my lady, will come in later because of the data, my lady. The data mainly relates to the second accused, and we will extensively use that data in giving his evidence. And because it is still not with us, we make any meaningful step, my lady, with that data. We undertake to look at it in the quickest manner possible, so that now when he eventually takes the stand, we can, without occasioning any further adjournment.
Open his case, then call his witnesses.
My lady, without prejudice, a reading of section a reading of section 3 or 7 is silent on the order in which decides how he wants to defend himself, sworn statement or calling witnesses. Our understanding, and we could be wrong, my lady, but our understanding is that you organize your case as you deem fit, so long as the accused will be one of the witnesses to give evidence. The understanding, my lady, is that all the witnesses an accused person calls is part of his case. It's part of his case. So whether he chooses to go first or he chooses to go last, our reading of this section is that it really doesn't matter until that particular accused person testifies. Understand, to be corrected, my lady. We are not holding that as the gospel to
use the word ideally.
Yes.
Ideally. That should be the position. But we have the senior counsel with us. Maybe we can pick his brain and your input on this.
Yes, before you came to court, your ladyship, we had this discussion with Mr. Oganda. And I told him from my experience and the case law around section 307, the accused must testify first before any other evidence is taken. That's what I've seen throughout the years I've practiced. So I told him his preposition sounded strange to me, but I left it at that. I think he can confirm we did have that discussion, and that we looked at the section, and the section also his case. That's why I can say, your ladyship.
His case may, stating the facts or law on which he intends to rely on. And my lady, we take this to mean maybe an opening statement, like the prosecution did, and making such comments as he thinks necessary on the evidence for the prosecution. The accused may then give evidence on his own behalf, and he or his advocate may examine his witnesses. Again, may, if any. And after their cross-examination and the examination, if any, may sum up his case. May, again, my lady. He may choose to open or...
We are still conversing with the lead counsel. Can we hear what you have?
Present his case, and if he has any witnesses, he then may bring such other witnesses in support of his case. But the procedure, as I understand it, is the requirement to be given the accused person to present his case. Any witnesses, if he has, only come in to support the case he has presented. That's been my understanding. I also understand from his very kind suggestion, I think he was trying to save the day today, that now that without the Safaricom documents he can present his witness. I think he was being very kind to the court and to us to save the day by presenting another witness, but that will be entirely with the court. I understand.
My position is that the section presupposes that the case belongs to the accused person. And so, when the case belongs to a particular person, it is Taugada maybe wanted to save us the day, so that we do not let the day go to waste, given that he may not be able to proceed with his client's case in the absence of those particular documents. But my interpretation will be that the owner of the case lays down their case, then should they have witnesses, and that's it. That's my opinion.
To defend himself through testimony always appears before the other witnesses as he's testifying. Now, unless he's basically saying that he won't testify, then the other witnesses may go ahead. But from my experience, the defendant always opens his case.
Left out in an interesting conversation.
Yes, I can see he's looking at me.
Well, I think I agree with all my colleagues. Of course, exactly, so I have not seen an accused person's witness coming before the accused person himself. But Sagana, in I think appreciating Mr. Ogada's effort, and I think when we last appeared before you virtually, Ms. Msando actually mentioned that they present witnesses who will not need to use the data. I think that one was mentioned. So in his efforts to save the day for all of us, I think as to whether they will proceed as suggested. Thank you.
Yes.
Because I just thought it was a very interesting approach.
It is, my lady. It is indeed interesting.
To hear what the others think about it.
Because, and I'm glad we are addressing this off record. A few paragraphs of that section of 307. My understanding is that those are generally opening statements. So that now, after the accused person has presented his witnesses, he may opt to close his case. Again, now closing statement. Our law does not provide expressly opening and closing statement. That's a system in the American legal system. In our country, the law does not expressly say you give opening statements the way Ms. Mwaniki did when we began this case. Be it as it may, my lady, you may say every day we practice law because every single day you meet a new challenge. And we say we practice, even with Senior Kilikumi's vast experience, he still practices law. Because he's not perfect, he practices, even if you know it will be given by court. And because, my lady, we personally, the court adjourned to accommodate me. I thought it prudent we save time. Because even the data, my lady, that will be given, we every day, we look at his data and patch up a few sources on it, and then finally we present him. That is how we are intended, so that we don't occasion an adjournment from our side. My lady, I undertook to conclude my case this week, if you can remember, my lady. So that is what I intended to do. Defense of the second accused. So we wanted to dispense with them quickly as they come. So the second accused, who is not the state with the resources to keep a witness for so long. So that was our respectful approach to this, my lady. True, my lady. And I'll give you, for instance, my lady. Let's speak randomly. We need to show, for instance, my lady, where the second accused was, whether he did when. We thank Safaricom for agreeing to give us the data. My lady, had the prosecution given us a complete set of data,
My lady, we object to that. We supplied all the...
You know, my lady, we are also entitled to our opinion. Our opinion is that the data they supplied us is not complete. They supplied us with data, but not complete. Some basis was laid for you to allow the application. So, yes, that's what we are saying.
he will give his evidence based on what is within his knowledge or what the truth of the matter is.
Correct.
So that it is not expected that you be referring to any data. It is expected that he will be telling the court and everybody else the truth about what he knows about the subject matter of the case that is facing him.
Yes.
So that it is not expected that you be relying on that.
But would the evidence be much stronger if he gives the truth when he gives the truth and points to the correct data as to where he was, as opposed to just saying, I was in Uganda without something. So that which he will point to, my lady, is what we asked you to allow us be given. And we got the order and Safaricom has agreed to give. And my lady, we are saying, so that we don't again waste today. And based on our understanding of Section 307, we wanted to begin with the witnesses who are here. Who are, anyway, Section 307 of the Criminal Procedure Code, to begin with other witnesses other than the accused, the second accused person.
Criminal Procedure Code.
I said code, my lady. Criminal Procedure Code. CPC. Section 307 of the CPC, my lady. Really, our application is supported by grounds that, one, the section provides for the section is conditional on how an accused person chooses to conduct their defense. My lady, the word may, as used in that section, gives the accused person options. For respective dates when the transaction of this case occurred.
An application to be provided with.
Application dated 9th May 2025 for Safaricom to provide the second accused with proper and or complete data. Immediately, the second accused intends to use this data, which is not currently available at his disposal, to present his case. The second ground, my lady. My lady, for an expedient use of judicial resources, the second accused is asking court to allow him not to waste this precious judicial time this morning, and that we begin with the available witnesses before he gives his testimony. My lady, the call data sought by the application of May 9th is so crucial that its absence will occasion great miscarriage of justice on the part of his defense. It is our respective submission that where the law is silent on how the defendant must proceed, then you are clothed with the discretion to guide your court as to how it must proceed before you. Hence the making of this application at this juncture. In the alternative, my lady, in the event that court finds that our application is premised on wrong application of the law, then the court should allow us, the court should allow the second accused advocate to give his opening statement as we await for the court that. My lady, the case for opening statement is clearly provided in section 307, which says the accused person or his advocate may then open his case. Like, because the accused person's advocate is not on trial, then he simply means he does an opening statement. For those grounds and the law, we pray that you allow application.
Your Ladyship, I'm not sure whether we are entitled to respond to that application. I think I'll leave it to the court. Yes, thank you.
To object, but all I know is the procedure that we normally deal with is that the accused opens his case. That is what we are used to. And for me, let me just say I'm objecting, my lady. Let me just say I'm opposing his application.
Give you time to decide how you want to proceed.
I'm trying
because
to see.
You represent the state.
Yes, my lady.
This is the state's case against the accused persons.
Yes.
An application has been made by one of the accused persons. So you need to respond substantively.
Yes, my lady, I do need to respond substantively because this will also affect the matter of the case. My lady, on our side as a prosecution,
can give you
a few minutes. Thank you,
1 hour.
Yeah, if
your thoughts and decide how to.
Yes, my lady, if you can give me a bit of time, so I can just consult.
Okay.
If you can
How
give me
much time?
30 minutes.
30 minutes.
Yes, my lady.
Yes, the standard today it is the standard coincidence.
Okay. So. Good morning once again.
Good morning. On the prosecution side, my lady, on behalf of the Republic, apologies. Lady, for the prosecution on behalf of the Republic, we oppose the application by the second accused to have another witness start the defense. My lady, our view is that the second defendant should open his defense by giving testimony in this matter, if that is how he chooses to defend himself. By giving testimony in this matter, if that is how he has chosen to defend himself. My lady, our objection is premised on Article 52F, which 52F, that deals with fair hearing and states every accused person has a right to, which includes the right to be present unless the conduct of the accused makes it impossible for the trial to proceed. So we read that as present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. My lady, our reading of this section of the article states that the accused must be present for every facet of his trial, prosecution and defense stage. And the question is,
Has been present
every stage of his trial, prosecution and defense stages in specific. Then going on to judgment and sentencing. This is a constitutional requirement. My lady, we also refer to section 307 of the Criminal Procedure Code that you are read out for. And my lady, we compare it with the provisions in section 211 of the CPC, which deals with the lower court defense stage, which gives more details on how the matter should proceed, the defense stage should proceed. My lady, it is our reading of these two sections in a comparative view of the two sections that it was always intended that accused person starts the defense by defending himself personally from the allegations raised at the prosecution stage, and we believe it will be incompatible if he is allowed to be present and other witnesses are able to give testimony. Then he comes and gives testimony. It will be incompatible with the constitutional requirements and the sections I've talked about for the defendant, for the accused persons, the second accused person, to be in court during the testimony of witnesses which he will then be able to incorporate into his own testimony before this court. Melody. Witness testimony is to be impartial and independent and without taint. And that is why we do not allow and without taint. Yes. And that is why we only allow a witness to testify when all other witnesses cannot hear him or outside. They cannot be in the same space, which is what the second accused is attempting to do, to be in the same space, to hear the testimony, which will clearly be tainted. Melody, we can also not have him leave the court because he's supposed to be here throughout the trial process. And that is why Section 37 talks about him opening his case. 307 speaks to the defendant opening his case. Sorry, my lady, computer has gone down. It talks about the defendant or accused person opening his case, stating the facts or law on which he intends to rely upon, and that the accused may then give evidence on his own behalf, and he or his advocate may examine his witnesses. So, my lady, it's a step-by-step procedure, and the court should follow the step-by-step procedure provided in 307. You can also refer to the lower court section 211, that we have always envisioned, that it was envisioned by the drafters that the defendant would be the first witness if he's testifying under oath to give testimony against a prosecution case, and the other witnesses would merely support his defense, and he would be in court to hear the same. Melody, the second accused, has also raised the issue that he was trying to save the court's time due to the delay of Safaricom documents. We understand that this delay is not of his making. As he has also stated that he would need time to consult his advocate and compare the Safaricom data to enable him present his case in a fair manner. My lady, from our side, we understand that that means they would require time. And we would not want the accused to state that we have rushed them, the prosecution has rushed them in this case, not providing them adequate time to prepare. We'd be willing to give some concession on time. But for the first accused, another witness starting this matter, my lady, that one we would object to wholeheartedly. But we'll be able to give time for the data to be available so that the first accused can start his testimony. That is all, my lady.
If you have anything to say in response?
In a brief rejoinder made earlier during arguments in support of our application, only we also want to agree with the prosecution that yes, we need time to look at those call data when they are availed. And indeed, counsel for Safaricom has said that the volume is huge. So that the second accused is adequately prepared in line with Article 52. That is all, my lady.
Okay. I can give my ruling in the next maybe 20 minutes. So that we can adjourn instead of keeping everybody waiting as I write. Then I'll come back with my ruling in the next 20 minutes. Of the second accused is that the second accused be allowed to call another witness before he testifies. The application is opposed by the prosecution, who has insisted that the accused ought to testify first, and that this is the procedure that is allowed under Section 307 of the Criminal Procedure Code, which is also in line with the fair trial rights of the accused. The application by Mr. Uganda appears to be informed by the fact that, according to the second accused, he is unable to start with his evidence today, which is the day that was set for his defense hearing, in view of unavailability of call data records that were supposed to be supplied by Safaricom, which are yet to be available and which, in his view, are crucial to his defense. I have considered the submissions made in support and opposition to the application. I have also looked at Section 307 of the Criminal Procedure Code, which provides the procedure of the manner in which an accused person who has been put on his defense ought to prosecute their defense. The provision is in the following terms. The accused person or his advocate may then open his case, stating the facts or the law on which he intends to rely on, and making such comments as he thinks necessary on the evidence for the prosecution. The accused person may then give evidence on his own behalf, and he or his advocate may examine his witnesses, if any, and after their cross-examination and re-examination, if any, may sum up his case. So it is clear from this provision that the only discretion an accused person has is to decide whether or not to make an opening statement. But once that decision is made, if he makes an opening statement, then he is expected to immediately thereafter give his evidence and then call his witnesses. So I would then agree with the prosecution that it is a matter of law that an accused person ought to start with his evidence before calling any other witness. And that also aligns with the Article 52, Subarticle F, because an accused person is required to be in court so that he can participate in the proceedings unless his conduct makes it impossible for him to do so. And that has not presented, that other scenario has not presented itself in this case. With regard to the prayer that if the application is not allowed, then the accused two's advocate be allowed to give an opening statement. I can only reiterate what I've stated earlier, that it is up to an accused person to decide whether or not they want to make an opening statement before presenting their evidence. They claim that the word may gives an accused person, the word may used in that section gives an accused person discretion or an option whether to testify first or not, is in my view misconceived, because in my view it is used in recognition of the fact that an accused person has a right to decide how to prosecute his defense and either give an unsworn statement or sworn statement, and may even decide to remain silent. So I think the use of the word may is used in recognition of the accused person's right to even decide to remain silent, so that if he chooses to give his evidence, then he can thereafter present his evidence. So my response to that prayer is that given that the law gives an accused person discretion to decide whether or not to make an opening statement, it is up to the accused person to tell the court or to inform the court whether he intends to make an opening statement or not, so that the court can now proceed the court can now proceed to conduct or to record the accused person's either statement or to proceed with his case. So the sum of this ruling is that I decline to allow the application and direct that the accused ought to give his evidence first to lay a foundation for his case, and if he chooses, he can call other witnesses thereafter in support of his defense. He testifies today. It is just a ruling on the application.
Yes, madam. We appreciate your ruling. Yes.
So tell us.
We did say that we are yet to be served with call data, and that upon service we'll obviously need some time to look at it. And because counsel is now in court said that it's quite voluminous, the data is quite voluminous, obviously we need some time to look at it, and then now we start with evidence of the second accused in line with your ruling. So we want to wait for your ruling, then subject to being served with the data, we patch up what is left, and then now we put the second accused on the stand.
Okay. I can see Mr. Kiptines is here.
The data, call data records, they are provided in 3 different bundles. The largest bundle contains calls made, messages sent, and data sessions, which will reflect data. So it's call, message, and data, and it shows locational data.
Okay, let me take that. Give me a minute.
What we've provided in addition is 2 separate bundles which are identical to what was furnished.
So you now have data in 3 bundles?
In 3 bundles. The largest bundle contains the locational data which was specified by the second accused persons in the application as being critical, as the same was missing from the call data records submitted to the Directorate of Criminal Investigations. For clarity purposes, the data will show calls, messages, meaning text messages, and data sessions. Data sessions includes things like WhatsApp, going on to Safari to open a web page. WhatsApp, as an example, going on to Safari to open a web page. Anything involving the use of data is what is known as a data session. So it will not specify that this was a WhatsApp message or it was a Telegram message, but because it uses data to access that information, it will just show data. So it's calls, it's messages, and it's data with the attached locational data. There are certain parts of the locational column which contains unknown, and this would happen in a case where the phone attempted to make a call, attempted to send a message which it will show, but it didn't go through. The phone in this case might be on flight data mode, might be off, and therefore unable to ping the cell tower in order to identify the location of that cell phone. So this is just to clarify, my lady, that where it says unknown, it is not an attempt by the second respondent to hide the locational data. With that, well, the locational data shows unknown instead of showing a location.
My lady, I think at this juncture I have to oppose those submissions for obvious reasons. My land senior, Mr. Kiptine's role was limited to providing the data. He has no role whatsoever to explain that if they believe the data is complete as they think they are provided, they leave that to us. Because now the line is taking, I may need to cross-examine when we made that day was informed by some expert opinion elsewhere. We've had this data since 2018. But the point when the second accused person was prepared robustly for his defense, certain information came to our knowledge, and that is what necessitated making of the application, which you graciously granted, and we thank you for that. Therefore, my line senior should limit his role. He should not explain what is not in the data and what it means. If he does that, then we'll have to call him as a witness. Unfortunately, I don't know a witness for which part, because the prosecution closed their case. We do not intend to have him as a witness. If indeed, my lady, will need someone to explain those discrepancies, all that occurrence. I'm sorry for the word discrepancy. If we need to explain that phenomenon, then we know how best to do it. So let him just give us, and we thank him for bringing the data on time. To be given time, my lady, and we'll make that application. We will be allowed to scrutinize that data, and then we'll proceed appropriately. Otherwise, anything else he says is evidence, and that is not how we are going to proceed. We object to that line of
the data that had been given to the DCI at the time they requested for the CDR from Safaricom, just for them to compare and certify that the data they requested is what we gave to the DCI, as well as now additionally with the call data records locations. Calls going from party A to party B, i.e. between two phone numbers. When they perused the data and identified that perhaps locational data was missing, it's because it wasn't requested specifically. This data, milady, is captured from Safaricom's end for billing purposes. So when a request is made from law enforcement, they have to ask, what do you want? Now, the additional request that came through the court order of this Honorable Court, requiring the data with locational data, it required my client to go into the specific server and pull that locational data. And so what we have in this first bundle contains locational data. What we had given the DCI did not contain locational data. I'm happy to hand over the data to my learned colleague.
Or just documents. You were very specific in your application.
Yes, my lady. Yes, I can see the second accused number here. To distinguish which is what is what was added and all these things, my lady.
No.
We have to look vis-a-vis what we have.
I do not expect you to know the content.
Yes.
Because you've not had an opportunity to peruse through. I just wanted you to look at whatever has been provided and see whether the accused person's phone that you provided.
Yes.
And the duration. You can check the first copy to the last.
And the government is informed by the ruling just delivered that the second accused person must be the evidence person. Based on the call data we have received, we obviously and we kindly ask that the court allows us some time. Largely, our evidence is premised on this call data. It will be prejudicial for the second accused to start his testimony without having an opportunity to scrutinize. Already being given the data is different from checking whether the data is conclusive or not. And whereas we are happy that the letter has been provided, we ask this court, our colleagues and the prosecution, to accommodate us to go look at this data. And then now, my lady, when we begin hearing, we will be able to, once we are done with the evidence of the second accused person, the other witnesses will be shot. The other three also witnesses will be short witnesses. So that is what we are seeking at this juncture, my lady. We are proposing we start on Thursday. It's a proposal, my lady. Obviously, you can see the bundle, you can see the volume. I know the prosecution may want to say it's the same data we have. We cannot confirm that. We also need to pass this to an expert to also help us decipher what indeed this says. Because even a cursory look at it, my lady, I can still see certain columns are blank, and I think that's what my lady was attempting to explain, which we refused, and for a reason. So if they indeed still hold the position that this is the data as it is, then now we also have to sufficiently now bring in that expert to come and give certain clarifications. My lady, we were hoping that perhaps what we had, and this is different, and indeed I can see certain locations are there. This is a little bit more comprehensive. We had hoped that all the columns would be complete so that there is no need to call that particular expert. But obviously now, it seems we will still call that expert based on some instructions we were given earlier on. And that's why we call for Thursday, my lady, at least tomorrow and Wednesday. And then
objection to the time taken. Although my lady would request that we serve beforehand, if possible. But we have no objection to that judgment. No objection, I believe.
Then, on our part, we find that we can come back on Wednesday. We are of the view that the rest of the day and the whole of tomorrow is fair enough time to enable the second accused, together with his counsel and their technical team, to gather the relevant information to enable them to proceed on Wednesday. That was the proposal. Secondly, we wish to join the request by the prosecution. We had mentioned it earlier, but I think it did come out clearly. Our proposal was that when Safaricom was providing the data, if they could be requested to supply all the parties, because the second accused does not have an obligation to disclose until they choose to use it. So we are proposing that so that we don't have a request for adjournment during cross-examination, if the court could perhaps direct the respondents of this application to liaise with the bar to have those copies shared with us for our prior interaction, so that we are also prepared for cross. I think that would be orderly. We believe that is not prejudicial to any party. Because I know that Mr. Ogada, or rather the accused persons, don't have an obligation to disclose. They may even choose not to use it. But should they choose to use it, I think it's orderly and fair that the bar has copies. And I think if it is not too much work for Safaricom, then we will liaise with them to enable us with their copies. That would be our request.
Really remember that aspect. And that's why the benefit of I'm the junior most from this bench, from the bar, so I consulted my seniors.
Thought just before you make your response, so that when you stand up to address the court, you'll be clear as to what your position is, so that we do not spend a lot of time trying to interpret what you mean person to adequately prepare for his defense. Now that you've been provided with the data, and it is not as voluminous, I can see it. It is not that voluminous. And given your prayer that you be given up to Thursday to start the second accused defense, balancing those two, I would suggest, I would think that the accused person would have time in the course of today and tomorrow and Wednesday morning, so that we resume on Wednesday at 2.
Fair enough,
Not you will try. We will resume the hearing. And because I can see the documents, I know that will be sufficient time if you utilized it well. So
it's back to back, so it's done.
Yes. So we said that I allow the application, but on those terms, that the accused has time between now and Wednesday morning, so that hearings resume on Wednesday at 2 p.m. So we are adjourned until